And in particular, it relates to a possible theory of how a new methodology of deriving value from throwaway IP assets that are just being discarded right now. And in particular, I'm talking about foreign filing rights. Now, we all know that there is a market between buyers and sellers for granted patents. And I am posing the question here, could there be a market for buyers and sellers of your company's foreign filing rights? And let me frame the issue a little bit clearer. Let's say that a company here in India comes up with an invention and they file a patent application in India. And as we all know, within 1 year, that company is allowed to do filing outside of India and claim priority to that Indian filing under Paris Convention. Now, what typically happens is they decide to file in certain countries and they decide not to file in other countries. That determination not to file in other countries, they're throwing away an asset in each of those countries, which is their foreign filing right in that country, and they're not deriving any value from that. So a more specific example is, suppose that company A decides to file in only the US and Europe, or they file a PCT application at that 1 year period. But what about other countries like Japan, Brazil, Australia, China, you name it? There's many other countries out there where there could be a company or someone else, an entity, that may want patent rights in that country on that invention. So could there be a market between buyer and seller in that instance where the applicant, the inventor, sells their right to file in one of those countries they're not interested in and derive more value from their IP? And I think this is one area that's possibly not immediately, but in the future, could be a growing market for people to gather greater return on their ideas for these assets that they're just throwing away. Now, if you look at the motivations of both the seller and buyer, what are their motivations in this type of transaction? The seller, of course, wants to generate more revenue from this asset, this ability to file, say, in Japan. They want to derive some revenue from that if they can. Previously, when they decided not to file in Japan, as an example, they were willing to compete on the open market with other companies in Japan. The seller's motivation remains the same. They still want to remain able to compete on the open marketplace in Japan, but if they could find a buyer for that filing right in Japan, at that point, it becomes a contractual relationship, and those parties can negotiate what the selling price would be and what the innovator is able to do in Japan, and the innovator would likely retain the right to be able to sell product in Japan. But the company who bought that right is able to go and sue anyone else who might infringe. So there's value to both companies in that transaction. Now, what's the buyer's motivation? Again, they want some sort of ability to have a patent right to perhaps exclude others other than the original innovator company in that particular country, in this case Japan. And we've all heard about the rise of trolls, non-practicing entities in the United States. Those types of entities could be a huge potential buyer in this type of buy-sell relationship, where now they can shop around and buy a right and prosecute a patent application, file and prosecute themselves in a particular country, specifically targeting potential companies to go file lawsuits against. So I think ultimately there is a potential market for this kind of thing. And at the end of the session, I'd certainly like to discuss, if anyone has any ideas on this, pros or cons, discuss this further. But I see the, natural question is, who are the parties? Who might want to become involved in this type of system? And it seems to me that the most likely sellers in this type of system would be small to medium-sized companies, because they're the ones who would derive most value from generating this incremental revenue. The big corporate giants out there, there's probably not enough money involved on a per foreign filing right sale transaction to make it worth their while, at least initially. The potential buyers, I view them as all sizes. Major corporations might want to buy a foreign filing right to go after one of their competitions in a particular country. Again, the non-practicing entities, patent trolls, might want to buy these foreign filing rights to go after people as well. So I think on the buyer side, there's certainly a vast array of potential entities that might entertain buying these rights. On the seller side, it might be a little more limited initially, but yet still a large number of innovators are small, medium-sized companies and individuals. And especially if you look at India, where costs of filing in other countries outside of India might be prohibitive for a lot of Indian companies. And if they can derive revenue from this type of system, I think that would be very attractive to a lot of Indian companies. Like anything, there's problems, potential pros and cons in any system. The problems I see with this type of theory, obviously the biggest one is matching buyer and seller. How do you do that? How do you find a willing seller and a willing buyer, match them together? I don't see that as being all that different than what's done now when you're trying to buy and sell patents. There's companies, entities out there that a seller of a patent approaches and they go out and try to find buyers of that patent right. And I don't think a buyer of a foreign filing right is much different than that. Timing of this transaction might be an issue. If you're talking about arranging a sale within the 1-year Paris Convention period, that's probably not going to happen. The more likely scenario would be the applicant files a PCT application. It's given them 18 months to complete this type of transaction. Second major problem would be the applicant may need to disclose the invention to a potential buyer before their application actually publishes. If you can wait on the transaction until the 18-month publication period, whether it's PCT or elsewhere, that problem is probably resolved. Nonetheless, if you start trying to negotiate before the publication period, then the applicant's going to have to disclose their invention prematurely. A lot of entities might not want to do that. Third issue that I can think of would be, can a buyer of a foreign filing right, can they actually file themselves a patent application in another country if they were not the original applicant? And I think under PCT there might be some issues with that, but again, that can be resolved by contract where the contract says that the original applicant does the initial filing in the country and then immediately assigns the rights to the buyer. So there are ways around that. Final issue would be specific to the United States or any other country with some sort of information disclosure requirement. Would there be a requirement for the applicant in the U.S. to disclose to the USPTO any prior art that's cited in a application that was filed by that buying party? And I don't know the answer to that. A safe bet would be that you, again, contractually require that buying party to tell the applicant about any office actions and prior art that came up. But that is an issue that I don't know the answer to. So anyways, this is an idea that's been kicking around in my head for a while. Our firm tried something like this on a passive scale where we simply posted IP assets on our website from our clients that were potential sale or license, including foreign filing rights. And it just sat there out on the website and people could come searching for it. And over the course of maybe 2 or 3 years, we had 2 or 3 or 4 inquiries from people interested in some of those rights. So on a passive level, is that success or did it work? You can debate that. I think a more aggressive approach where you actively go out and seek out potential buyers, I think this system could work. And it's certainly an area where, again, the applicants right now are simply throwing away that asset and not deriving any value. And if they could even derive nominal value, I think that's a win-win for both sides, both the buyer and seller, and make a lot of our clients very happy if we can get some more revenue for them. So I'd be willing to entertain any questions, discuss this further after, but just kind of a interesting theory that I haven't heard anyone trying to do anything like this. But I think it's an untapped resource for realizing economic value in IPR. Thank you.
Well, thank you very much.